All right, I'm going to go ahead and get started. Thank you everyone for joining us. My name is Ana Maria Allaire. I will be the moderator for breakout session number 2, Navigating Enforcement Actions Impacting Employees. We will now take a moment for our panelists to introduce themselves. After that, we will jump into the questions. If you have questions, please feel free to place your questions in the Q&A and they will be addressed from there. Thank you. Paige, do you want to go ahead?
Sure, thanks so much. My name is Paige Eggleston. I'm an attorney at Bernstein Schur. I specialize in labor and employment in both the public and private sector, and I'm glad to be here today.
Thank you, Paige. Anne Marie, do you want to go ahead?
Sure. Good morning, everyone. My name is Anne Marie Story. I'm a senior counsel at Bernstein Schur. I've been practicing labor and employment law for about 26 years on the employer side, and I'm also happy to be here today.
Thank you, Anne Marie. And our last person and panelist will be.
Good morning. My name is Pete Hale. I am a partner at Pierce Atwood, also an employment and labor attorney. My practice, I've been practicing about 18 years now, and yeah, half my practice is advice and counsel and helping individuals in HR navigate sticky situations, and then the other half is litigating employment claims in court. So happy to be here and talk about these issues today. I'm also meant to say I'm on the board of Diversity Hiring Coalition as their program director.
Thank you, Paige, Anne Marie, and Peter. So we'll go ahead and jump right in. The first question that we have is has to do with ICE raids. What do I do if ICE agents show up and insist on entering the premises without a warrant?
Well, I can take that one, Anna Marie. If ICE shows up, and this is something I think people are really concerned about, is they show up, they insist on entering a private business, and they don't have a judicial warrant, or they have an administrative warrant, and they try to tell you, listen, this is good enough, and we're allowed to come in here, and they try to come in. I guess the first thing I would say is keep an arm's length. I'm going to say that repeatedly throughout this session. Don't physically impede ICE agents from getting into your business. Okay. We're trying to de-escalate the situation. We're trying to create a work environment that is safe and secure for our employees. And so by keeping an arm's length from ICE agents, that's the way that we help do that. If they're insisting on coming into your office without a proper warrant, I would say we need to first identify everything that's going on. So if they don't have a warrant, or if they have something they claim is a warrant, take a picture of it. Make sure that you document what they have. Document who it is who's there, what the name of the agents are. Want to document their badge numbers. If we don't have time to do that, take note of what they look like. How many are there? What are they wearing? What exactly did they say? And this is another critical point that you're going to hear me say throughout the presentation today is repeating the message that you don't consent to them coming onto the property. You can't physically stop them from coming onto the property, but the key here is once we either implicitly or explicitly tell them you can come into the property, then that is considered consent under the law. Okay, we want to make it clear that if they're there, want to come into your private business, don't have appropriate paperwork, that we don't consent to that. If you're a lower level employee and you don't have authority to either consent or not consent, you can say repeatedly, I don't have authority to consent to your entering the property. I'm not consenting to you entering the property. If they insist on coming into the property, like you can't stop them. Like you're not going to stand in front of them. You're not going to push them out of the way, but you just keep repeating that message and make sure that it's documented. If it's safe, it can be appropriate to take a video of what's going on. But again, the two keys are keeping that arm's distance, repeatedly saying that you don't consent to entry onto the property, and, documenting everything. Because what we want to do is we want to have a record. If something happens and we need to go to court, we want to have as solid a record as we possibly can. And that means taking note of everything that's happening and having evidence that we can clearly present to a judge. I don't know if anyone has questions about that. We can talk about it a little bit more, but
If I could just jump in, I think that Peter really covered a lot of important points here. One issue that I've seen come up with some of the employers that we represent are in the restaurant industry, where, if you're open for business, then anybody is permitted to come in to that kind of storefront area. It's certainly a separate question about the backroom area, which is not an area that's open to the public. So that's kind of one consideration to keep in mind that I think can be a little bit tricky for employers to navigate.
Thank you, Paige and Peter. Anne Marie, did you have anything you wanted to add?
Yeah, just to follow up on Paige's point, there have been a lot of interesting questions about what constitutes a private space for an employer, and it is very dependent on what kind of employer it is. It's actually, I think, easiest in the medical field because they're already accustomed to designating what's public and what's private. But any other employers should really take a look at their workplace before they are confronted with this situation, and be sure, to the extent that they can mark areas as private, that they have done that.
Thank you, Anne Marie. There are no questions from the audience at this time, so we'll go ahead and move on to the next question. If ICE agents refuse to show credentials or try to force their way onto property without any documentation, should I call the police?
I can start with that one again. The question of whether you call the police is always tricky because ICE is like, well, we are the police. Like a lot of times they'll wear, little badges, or they'll wear the word police across their chest. But there's a difference between federal agents operating under the Department of Homeland Security and local or state police officers. And state law and federal law are different. If an ICE agent is attempting to forcibly enter the property without a warrant. And one thing I forgot to mention is, in answer to the last question too, the other thing you should do is call your lawyer. If an ICE agent is trying to enter the property and they don't have what appears to be a valid judicial warrant, and we can talk about what that looks like. I mean, judicial warrant is signed by a judge, whereas an ICE warrant is usually signed by an ICE agent and doesn't give them the constitutional right to come onto your property. If anything like that happens, call a lawyer immediately. You should have a list of points of contact, your frontline person. If you have a receptionist, call a lawyer immediately. Because that's a really big deal. It's an emergent situation. Should you call the police if ICE is trying to get onto your property? You've called the lawyer, or it's emergent, like they're forcibly trying to get onto your property, refuse to produce credentials and refuse to produce a warrant. It is reasonable for you to call 911 or local authorities. You have to kind of make that judgment call. I mean, first, if you have the opportunity to call counsel, if you have the opportunity to call your HR people at work, I would do that first. But if it's truly emergent, if the ICE agent is getting physical with people, if you just get that gut feeling that this is kind of devolving into a situation where people could get hurt or people's rights are being violated, it's not unreasonable to call local authorities, because there may be a trespass issue. You don't want to have there be an assault issue. You don't want anyone to get hurt. That's, I guess, the short-ish answer to the question. I don't know if Paige or Anne Marie have any thoughts.
Thanks, Peter. Looks like Paige and Anne Marie Don't have anything to add. So the third question, how can I calm down my employees in the event of increased ICE activity?
Um, that's a tough one, how to calm them. Um, well, I mean, I think the first thing that you should do is I think people are calm when they have a sense of predictability. Like they know, okay, if they have a sense of preparedness. So if your employees know, okay, I'm scared of what's going on with ICE. I'm scared of the situation. I'm scared of, someone coming into my workplace, creating a disruption, people getting hurt. But if people know, okay, we have a procedure here, we have a point person, we have someone I can call who's an expert at this stuff, we have, we have a script for people to use if ICE comes on the property. Those things I think make employees feel safe and secure. If they have knowledge, if they have some training, um, I highly recommend that to all my clients is that if you can put together a policy on what to do if federal agents show up at your doorstep, if you can conduct short training, it doesn't have to be very long. It could be a half hour of just what is everyone's rights and what are they supposed to do if this happens? And then for people who are most likely going to interact with these agents, so I think, at least most law firms, it's like this. Like we have a reception area. You have a receptionist. Behind, outside the reception area, usually it's secured offices. So training your frontline people of what do they do if ICE shows up, or federal agent doesn't just have, that's not just ICE, it's any federal agent show up with a subpoena, with a warrant, whatever. Employees feel a lot more secure when they know their employer is taking this seriously. The employer has a plan, and the employer takes it so seriously that they are helping educate employees about what to do if this happens. Otherwise, employees, I mean, without the training, without the protocols, everyone's minds go into some pretty wild places. People start thinking up of scenarios, and that's where the anxiety and the fear start to come into play. So having that solid policy training, having a point person, or even a committee. Some clients have like you know, a committee or I don't know, yeah, like a committee or a group of people who they are the point people. Um, whom you call if something like that happens.
Thanks, Peter. Paige, did you have anything you want to add, or Anne Marie?
Anne Marie, you can go first.
Yeah, just one thought, and I have not seen this happen yet, but it wouldn't surprise me if at some point an employer actually saw a workers' comp stress claim resulting from all of this activity. Whether or not it would be work related or compensable is a whole different matter, but I could see it happening. And I think the steps that Peter talked about going through are your best way to mitigate the possibility, because at least that way you can show that you did have a plan, you did what you could to mitigate those feelings. And I don't know where that would go, but I think it could happen.
I was just going to jump in and build off on what Peter was saying in terms of a policy. And I think everything that we've talked about so far can be reduced to a policy, and that is really valuable for employees. One concern that I've seen come up, and I think that it's just indicative of a limitation of resources, is that if you have multiple locations, for example, and there's a point person that you would designate, but that person can't be everywhere at once. And that's why it is helpful to have multiple people available to step up in that point position. One concern that I've heard from employers is, well, the person that I would designate is uncomfortable in that position. And there are a variety of reasons why that person who otherwise would reasonably be the person to be the point person would be uncomfortable. And that's a tough situation to navigate. I do think, kind of going back to policies, that is helpful to bring at least a sense of predictability that Peter had mentioned.
Thank you, guys. We appreciate
I
it.
would, I
Oh,
would, I
go
would
ahead,
add
Peter.
one more thing in addition to policies. I mean, on a less legal um, note, I would say, a lot of employers have EAP programs. They have access to resources where, um, employees can use these resources for, mental health issues, counseling, feeling just more grounded and safe in their communities. And I know a lot of employers the EAP employees kind of know what's out there, but they don't really understand what it is or what it offers. Maybe it's like in times like these where stress is high, people feel unsafe. It might be a good time to help train up your employees on what the EAP offers and beyond just, putting it on your company's dashboard or something. It's sort of like an afterthought. Like really, explaining to employees, here are the benefits that we have. If, you're feeling stressed, if you feel like you do need to talk to somebody, if you feel unsafe, this is what EAP is. And then potentially also providing employees contact information for other resources regarding the issues that we're seeing. I know there's a lot of places that are helping support individuals who may be affected by the ICE rates. And so communicating and just letting your employees know, listen, the company's aware of what's going on. Beyond just drafting policies, we're aware of the impact this is having on people's mental health. And we're here to support that. We're here to help you through that difficult time.
Thank you, Peter. The next question is, what if ICE agents start asking my employees questions? Do they have to answer?
Ooh. Um, no, they don't. Um, you know, but the tricky thing is, what do you say to them as an employer? Do they have an answer? No, they have a constitutional right not to answer questions. You have a constitutional right to a lawyer. The tricky thing is, like, ICE starts going around. Let's say that they do have a warrant to come and search the premises. And so, as they're searching the premises, and I'm hoping that your point of contact is accompanying them everywhere they go and keeping them from going into areas they're not supposed to go. Not physically, of course, not physically preventing them. But the tricky thing is, like, you don't want to instruct employees not to answer the questions because then that could get you in some trouble. Um, but there's nothing wrong with advising employees, and this should be part of any training that you do, that they have a right to not answer the question. I mean, they can, if they want to answer it, they certainly can. But they have the right to refuse. They have the right to get an attorney. Um, And, I think the other important piece there is if they do choose to speak with ICE, or if they choose not to, as an employer, you should not retaliate against anyone for making a choice one way or the other. That is their personal choice. And that can get you into some trouble, into some legal trouble if you start retaliating against people because they choose to speak with federal agents or not. I think that's all I have on that. Any other thoughts from anyone else?
Thank
No.
you. Again, if you have any questions, feel free to put them in the Q&A. I will be monitoring that throughout the session. And the last question in this section is, what can I do if a significant number of employees call out of work because of increased ICE activity?
Yeah, that's a tough one because that was happening there for a good while. What you can do, I mean, if people call out, they call out. I mean, you can't physically force them back into work. I think as a supportive employer, you again want to provide the safest, most secure workplace that you can, and you want to provide employees with the resources available to help them feel safe and secure in coming into the workplace. Um, a question that I do get is like, can I discipline people for being out because they feel unsafe? Um, and that's a tricky question. I hate saying it depends. But it really does depend. It depends on the person's situation. It depends on their history. It depends on are they in a protected class or not. Um, you know, it, I mean, these are and also aside from just the legal aspect of if I discipline someone for taking time off because they're afraid of an ICE raid, there's also just the morale issue of, well, how does that feel to people? Like if I start disciplining people because they're legitimately scared to go out in public because, Operation Catch of the Day is going on and they're hearing reports of people just being yanked from their cars by Whole Foods. Um, do I really want to start cracking down on people because of that? I don't know. I think it's kind of a judgment call. Um, Yeah, I don't, Anne Marie Page, I don't know if your clients have come to you with that issue. Um, but that's my thought on it. I don't know if you'd want to do, even if legally you could, I don't know if you would want to start disciplining someone for that.
Yeah, I think this raises a pet peeve for me, and that I think employers forget, and that is that if employees have time available, they're entitled to use it for whatever reason. Now, there may be buckets of time that they have to give you particular notice for, but chances are they've got EPL or other time that you've designated as, or legally can be taken as emergency leave with no notice. And so before an employer even considers denying leave in a situation like this, even if you were going to do that, you should go back to your handbook and make sure that whatever individual employee is seeking to take time actually has the time available, and look at it whether you can deny it or not, based because that may be your answer, is that it's available, they're entitled to take it, and you don't really have any say about it.
Yeah, Anne Marie, I agree. Again, if the paid time off is available to the employee, I think it is a more clear-cut question. If the employee doesn't have paid time off accruals, the only other kind of policy that I could think of would be something like an unpaid leave of absence. And we oftentimes see that, of course, when an employee may need time off due to an illness or a condition that could trigger an ADA analysis. And this is a very different situation. So it could certainly set a precedent too for the future, which is, of course, something to keep in mind when you have a policy like that an unpaid leave type of absence policy that could be used in a lot of different circumstances.
I mean, there are other ways it could be discriminatory too, potentially, because if there's an individual who is from a different place and their concern is heightened because of the activity, and you deny that person the ability to take time off, then you potentially could be looking at a national origin or a race discrimination claim on that basis alone. And I
Mhm.
also think, as Peter alluded to, if you've got somebody who's that stressed out and that upset, do you really want to have them in your workplace? Because it's gonna have an effect on other people, and then on morale and whether or not work is even getting done and all those other things.
Yeah. So I just, and this all, this sort of, reminded me of one issue in terms of, do you want to discipline someone for taking the time off? Disciplining someone for taking the time off is a lot different than disciplining them for failing to comply with call-out procedures. So, like, it's one thing, if someone is calling you, whatever, 24 hours notice, or they get in touch with their supervisor in advance and say, I'm not comfortable doing this, I'm not comfortable coming into the workplace. It's another thing if they just don't show up to work for like 3 days and don't call anyone. So I think there's, you just kind of, again, it's really a judgment call. And if you're not sure, you can always call your employment attorney. I think that's often, I'm sure Paige and Anne Marie can attest. Like usually if a client's not sure, it's a quick call, usually 10, 15 minutes. I'm not quite sure. Here's what's happening. This person, I'm pretty sure they're not coming into work because they feel unsafe, but I haven't heard from them in 2 days. I don't know where they are. It's a no call, no show. Just call us and we can talk through it.
Thank you. We're going to switch over now to I-9 audits. The first question in that section is, what is a notice of inspection pertaining to I-9 forms?
So I'll take that. A notice of inspection about I-9 forms, of course, is different than the process that Peter was just talking about when ICE shows up, although because normally it's received by an employer through certified mail, although it can be delivered in person. But a notice of inspection is generally asking an employer to produce documents, which of course are I-9s, but also some related documents sometimes, including payroll. Could be a list of your current and former employees, could be other corporate documents related to the formation of the employer and certain licenses. The notice of inspection will include information about where the document, so it will detail the documents to be produced, and then it will give you information about where to deliver it and when to deliver it. Employers should always keep in mind that if this arrives by person and somebody just shows up, sort of like an ICE agent showing up, as we just talked about, you do have 3 days to produce this information. So you should not panic and, pull out your binder where you keep your I-9s and just hand them over. The sort of the general, I think, advice, at least from my standpoint, is take those 3 days. You're entitled to them. Make sure things are in order. Don't panic. Call counsel if you need to do that. And then get the information together so that you're clear that you're producing the things that are actually being asked for and that you're making a complete production.
Thank you, Anne Marie. Peter or Paige, do you have anything you'd like to add at this time? Okay.
Nope.
The next question is, where should employers maintain I-9 forms?
So I-9 forms, they are part of an employee's personnel file. And so they should be in the personnel file. But most of us, I think, advise employers that it's not a bad idea to have a separate binder that includes all of the I-9 forms from all of your employees so that in the event this does happen, it's a lot easier to get that information together in a quick way, especially if you have a substantial number of employees. You don't have to go digging through their personnel files. The other reason to maintain the forms in a separate binder is because if ICE does show up with a warrant for this information, which could happen, then if you don't have it all in the same place ready to just turn over to them, they're going to start digging through your personnel files. And that is definitely not something that you want to happen.
So this is kind of a follow-up to that question, which you may have already answered then. Would you recommend keeping those forms in paper or keeping them electronically?
Well, they can be kept in either way, and so I would recommend that they are kept in the binder in paper form. But if an employer maintains its documentation, including personnel files, in an electronic way, or they just want to keep the the I-9s in an electronic way, you are permitted to do that. There are a few parameters about what has to happen if you do that. They have to comply with DHS standards, which means that whatever way you keep them has to be confidential and that they can only be accessed by authorized personnel. You have to have a backup system in place just in case. you have to have a way to track when the document was created. Anytime it's audited or changed in any way, you have to be able to show ICE that documentation. And importantly, you have to have someone there who knows how to access it in the event they're there with a warrant and they want the information immediately, and that's the only way you maintain it. You need to be able to do that in a quick and efficient way. And also, if you're going to print it out, you have to maintain it electronically in a way that allows it to be printed in a readable way. So yeah, I think most employers probably have a combination of paper and electronic.
Thank you. And for how long should they keep the forms?
So an employer is required to keep the forms either 3 years from the date of hire or 1 year after termination, whichever is later. I know there's been a lot of debate, and I'd be interested to hear what Peter and Paige, what their thoughts are about this by employers about whether they should just maintain them forever so that if anything ever happened, that they could always have access and go back and show ICE whatever they needed to show them. That's one school of thought. And then there's another school of thought that basically says if I don't have to have it and it could cause problems for me in the long run, then I'm not going to keep it. And and I'm only going to have what I'm required to have. I tend to fall in the latter category. And so I would say go with the 3 years or 1 year from termination, whichever is later. But I'm interested in my colleagues' thoughts about that.
Anne Marie, it's interesting that you raised that because it's something that I'd like to talk about a little bit more later on when we're thinking about payroll records and how long you're supposed to keep them versus how long you may want to keep them. And this does raise an interesting question. And maybe one compromise is keeping it as an e-record because then it's not filling the filing cabinet. But yeah, it's a good question you've raised.
Yeah, I also tend to agree with Anne Marie. Um, because I think with I-9s, the penalties are so stiff for even the um smallest error.
Yeah.
As long as you are 100% certain that your retention policy regarding the I-9 is compliant with applicable law, then I am okay with that. Of course, if there's a litigation hold in place, if there's anything like that, you just need to be careful with those automatic destruction policies and protocols with IT. But yeah, I think if there's a law that says you don't have to have it after a certain date, then you don't have to have it.
Thank you all. That was really great information. If ICE brings a notice of inspection, do I have to produce the I-9 forms right away while they are there? And I know that Anne Marie, I believe, was kind of alluded to that, whether they may ask for it immediately or not.
Yeah, so again, if they bring the notice of inspection, then you would have the 3 days to produce it. And I again would reiterate that I would take that 3 days. The difference would be if there was a judicial warrant that specifically allowed them to take the documents at that moment, then you would have to comply with that. And then I think you're back to sort of the processes that Peter talked about before, which include calling counsel and making sure you're doing the right thing. And also, I guess it bears repeating that if you're going to do the training that Peter talked about on what to do if ICE comes in for non-I-9 related reasons, you may as well talk with them, your management or whoever's going to be in charge about what to do in the event they come asking for the I-9. Somebody should know where they're maintained, how to put my hands on them easily, and and those procedures.
Thank you, Anne Marie. Paige, Peter, anything to add at this time? All right. Should we conduct an audit before ICE comes?
Again, a loaded question, and I know there are certainly different schools of thought about this. Some employers I've spoken to have said, not going to do it. I'm afraid of what's in there. I don't want to know. I don't think that's the best approach to this. I think this is very much find out now what your problems are and fix them. I've done many I-9 audits for employers, and I can't say I've ever walked away never finding anything that needed to be fixed, but I don't think that's unusual. And I think most of the issues that need to be fixed can be done so fairly easily. And it's far better to get those done before ICE shows up.
And Anne Marie, if we do an audit, how would we go about doing that?
Well, the first thing to do is to be sure that you're doing it in a non-discriminatory manner. So please do not just pick out certain employees to audit I-9s for. I think this is an all or nothing. So if you choose to do one, you're going to do it for all your employees or none of your employees. And I know that employers sometimes grapple with the issue of whether or not to let employees know that they're doing this for a variety of reasons, one of which is that they don't want to cause unnecessary anxiety amongst employees. But ICE actually recommends that you do tell people that you're doing this to give them notice. And that way, if you do have to go to an employee to correct something that's on an I-9 or hopefully this wouldn't happen, but to have to go through a process of completing a new one for whatever reason, they're not going to be surprised and they're not going to be worried about it in the way they would if they didn't know this is why you were asking. So I think number one, decide, yes, we're going to do them or no, we're not. And if we're going to do them, we're committed to doing them for everyone. Let your folks know and then start the process. And I guess the process is one by one. You can go alphabetical, you can go in whatever order you want to do. I would, just have a plan, an organized plan, and just go through them one at a time.
What are some common errors in the I-9 forms that people tend to see?
Well, they can be anything from errors on the forms themselves to more substantial errors like not having them. And I certainly have done audits where employers discovered that for whatever reason, they do not have an I-9 for a particular individual, or they have one and a section of it was not completed. Most often it's not the employee section, most often it's the employer section. Or they find that the documentation is wrong, or they can't read it, or there's a variety of things that could come up. You may also find that it wasn't done in a timely manner because, of course, there's rules about when the I-9 has to be completed, and that's within 3 days of the date of hire and the first day of work. So you want to be sure that they were completed in a timely way and dated in a timely way. And we were just talking about the time you have to retain them. If for some reason somebody didn't know what they were doing and trashed I-9s for a bunch of people too early while they're still employed, then that's something that you would need to fix. But I think a lot of it is, somebody didn't sign it here, or somebody didn't fill in NA in this box, or they didn't put their date of birth, or some minor corrections that can be solved pretty easily.
And what should someone do if they find errors?
So that's a loaded question because there are a lot of different procedures and it depends on what kind of error you're talking about. It also depends on where on the form the error is in terms of who can correct it. So as an example, if the error is in section 1, which is the section the employee completes, you cannot just add in, as tempting as it may be. If, let's say, the date of birth is missing in that box, although it would be easy for an employer to just fill that in from other information in the personnel file, you cannot do that. So you have to have an employee correct whatever is incorrect on that form. So the way they do that is to, if the information is there but it's incorrect, then the employee draws a line through the incorrect information, adds in the correct information, and initials it. If it's a matter of missing information, then the employee fills in the missing information and initials it. And there are separate rules if an employee had a preparer the first time they filled it out. There are rules about that. So I would encourage, this is a very brief conversation about this, and there's a lot to this. So if you're an employer and you are in that situation, I would very strongly encourage you to seek counsel if you do find errors, just to be sure you're going through the procedures correctly. The same is true for section 2 in the section that the employer was supposed to have filled out. If there's missing information, you add it in and you initial it. If it's incorrect, you mark it out and you put the correct information and you initial it. One issue that comes up sometimes is that you do an audit and the employee is no longer working for you, but you're still within the time frame to have had to keep it. So that if it's within 1 year of their termination and you do the audit, they're not there to fix it. You don't have to track them down and ask them after you've terminated them to come back and fix their I-9 form. You can attach a statement about the fact that they are no longer there and attach that to the existing form, and that's the way you fix that. One thing to note, I'm sure everybody listening knows this, but you never, ever, ever white out information from the original I-9. You don't erase information from once it's on there, and you can't get rid of it. All you can do is correct it. So that's a very, very important point. ICE, then there's some good direction from ICE actually on their website about a variety of problems that employers might have to deal with during an audit, and I would encourage people to look at that. One thing they address is if there's, and hopefully this will never happen, but if there are so many errors on the original I-9 form that you can't effectively correct them all, then you can create a new I-9 form and replace it. But again, you have to attach a description and an explanation for what you've done. So this document from ICE goes through a variety of other things that might happen. So for instance, if you find that you used the wrong I-9 form at the time you completed it, they have some direction about that. Essentially what you can do is not create a new form, but write an explanation and attach it to the old form. And hopefully that will pass muster with ICE. There are issues that might come up about the documentation as you go back and review it. So the rule is if you keep copies of the documentation when you're filling out the I-9 form, you have to keep those copies with the I-9. So if you're going back and you're doing an audit and now all of a sudden you look at the documentation and you think, wait a minute, either that's not sufficient or now it raises questions for me. Maybe you're a new HR person and your judgment is different than the other HR person. You do have to be careful about that because you don't want to look like you're targeting a person in particular. And so it basically reverts to the rule about if it looks genuine and reasonably acceptable, then you accept it now and you don't go back and question it. If you do question it, you have to let the employee know and have that conversation and then give them an opportunity to choose a different document from that same category. So you don't just trash it and start all over again. So that's just a few examples of things that you will have to do. Again, the type of thing that might come up is pretty endless other than the minor errors that you can fix. So I would very strongly encourage employers to, have counsel or someone else who knows how to do this either with you while you're doing it or at least available to answer those questions as they come up.
Thank you. And the last question in this section, what if we find out a long-term existing employee doesn't have an I-9?
Yeah, I mean, that does happen, believe it or not. So what you would want to do is create a new form now, and you would use the current I-9 form, even if the I-9 that you would have used when they were hired was a different form. You use the current form. You do not backdate it. You date it for now with the employee's date of hire. And then again, you attach an explanation for why you're using a current I-9 form for someone who was hired 15 years ago.
Thank you, Anne Marie, Paige, and Peter. So if anyone has questions, again, you can put them in the Q&A, but we are going to be moving on to the next section, and that is navigating litigation, administrative enforcement matters. And the first part of this is going to be third-party subpoenas. And the question is, when would an employer or an employee receive a third-party subpoena? And like, why would it come up?
I'll jump in. And it's an open-ended question. There are a lot of different reasons why a third-party subpoena could come up. And I think the first place to start when we're thinking about this is the framing here. So the employer is not involved with the litigation or the events leading to the subpoena. The employer is the third party here. So if you as an employer receive a subpoena, it could relate to so many different types of controversies or proceedings. And so really your nexus is to the extent that you as an employer have information or documents that the parties to that matter feel are dispositive to the proceeding. So not to sidestep the question, there are so many circumstances where a third party subpoena could come up. And in terms of the regularity of it, I would say it depends on the industry that you're working in. In the public employer context, this can happen when a 911 call recording is requested for the purpose of a proceeding, or other types of records maintained by a public entity that could be subject to confidentiality requirements, or the healthcare industry. There are a lot of different scenarios, and in some workplaces you may never see this happen. But it is important to keep in mind that it can come up, and there are a variety of reasons why. And depending on what the subpoena is asking for, really kind of guides your analysis.
Thank you. Anne Marie or Peter, did you want to add anything at this time? Okay. What are an employer's obligations when in receipt of a third-party subpoena for documents?
It's another question where the answer is it depends. So really the first question is, what are the documents? And are there any provisions of law that make those documents such that you cannot release them? They are for whatever reason deemed confidential. And I think the straightforward test is, if anyone asked for these documents, separate and apart from whether there's a subpoena, are you allowed to produce them? And if you can, then you may not have an immediate obligation to produce those records. But that doesn't mean you have to ignore, or you can ignore the subpoena. You have to respond to it, and you have to go through the procedural process. So first question is, are these materials deemed confidential? And I guess I should back up and say, you should call legal counsel, and they're going to help you kind of navigate this process. And that's question number one. Are these materials confidential? And if they are, then the next step would be to challenge the subpoena and go through the procedural process as a third party. That would ultimately end up leading to the court deciding whether or not these materials are releasable. And while a subpoena can't necessarily compel you to produce records that are confidential under a provision of law, a court order can compel you to release those records. And if you get to that stage, then it demonstrates that you did everything you were supposed to as an employer to safeguard those materials. And if the court's the final say, if they say that it's releasable or releasable under specific circumstances, then you would need to comply with that.
Thank you. And the final question for third-party subpoenas.
I wanted to just
go ahead.
Throw in a quick comment on that. To Paige's point about calling counsel, when you get a subpoena, it is critical that you act quickly. I've had clients who come to me and they get a subpoena in the mail, or they get it served on them, and then I look at it and I'm like, oh, this is 30 days old. Or oh, the deadline has passed. The reason that's so important to jump on it quickly is you only have so much time to object or to file a motion to quash. And once that time has passed, you've waived those objections and you have to produce the documents. Or worse yet, if you don't do anything and the time to produce documents or the time to appear for a hearing or trial has passed, you could be subject to a motion for contempt by the attorney serving the subpoena. So it's really, really, really important that people know when they see something like this that they jump into action immediately. Um, and that's even involving, protected health information. There's a provision in HIPAA that basically says once so much time has passed and nobody has responded to the subpoena, the healthcare facility is able to produce documents that are otherwise protected under the law. Um, it's just really tricky, and you want to really be careful about what you produce. And another thing is like you want to look carefully at what the subpoena is asking for because you don't want to be dragged into the lawsuit either. So that's why it's really critical to engage an attorney at the earliest possible stage so you're preparing for everything that could come from it. I mean, sometimes it's subpoena because it's like, an employee's in a divorce proceeding or, an employee got in a car accident and they need wage information. But other times, who knows what it could be? It could be related to a non-compete lawsuit and you don't want your company getting dragged into it. And so that's why it's important to really jump into action so quickly.
Yeah, Peter's absolutely right. Provided that service is proper, you have 14 days to file that motion to quash. So it's pretty quick, and a lot of things have to happen on the legal counsel side to make that happen and to meet those deadlines.
Thank you both so much. And the final question under third-party subpoenas is, what are an employer's obligations when an employee has received a subpoena to testify?
Yeah, this is an interesting question. I've seen it come up several times, and I've advised employers, and then by extension their employee when this does come up. In the cases that I've experienced, it was reasonable for the testimony to be compelled, and it was possible for that employee to participate. So this analysis is a little bit different from documents, which I think are a little more straightforward in terms of the steps. With respect to testimony, if it's likely that the court is going to find this to be compelling testimony and helpful for the proceedings, it may not make sense to challenge it. You could if you wanted to, but I do think there's kind of a cost benefit analysis there as well. And if it's likely that it's going to happen no matter what, and depending on, how much financial resource the employer wants to put into it, it may make sense to focus your energy on preparing that employee for that testimony. And so, you're reaching out to legal counsel for guidance on this, and legal counsel can work with your employee to prepare that employee for the testimony. It is not necessarily the attorney representing the employee specifically. It's within their scope of employment. So at the end of the day, the client is the employer. And then, ultimately that employee can be prepared to navigate that process to the extent possible.
Thank you so much. So we're going to be going into our final topic. We're moving away from third-party subpoenas into state and federal wage and hour audits. The first question we have is, what does a wage hour inspection investigation look like? And I can also answer some of that too, as I work for the U.S. Department of Labor, but I'll let you guys start if you'd like.
I think that your insight would be really, really fantastic in this section, actually, and I'm happy to kick it off. So when we think about wage and hour inspections or investigations, I think the first question is, what are your obligations as an employer? And state and federal law have specific requirements regarding how you maintain payroll records and what records you're required to maintain about an employee. All good employers know what those items are, and you are required to keep true and accurate records of them. In terms of the length of time you're required to keep these records, it's generally 3 years. And that can vary a little bit depending on if there were a claim brought by an employee for a wage and hour violation. I believe under federal law, the record requirement is 2 years, but 3 years in the case of a willful violation. Maine has a more stringent requirement. So with respect to bringing a claim, it would be 6 years from the date of the violation. So that's a longer period of time. But you as an employer are only required to keep 3 years of records into the past. So it kind of goes back to that conversation we were talking about a little bit earlier. How long do you want to keep records? Well, the law tells you that you're required to keep them from a certain period of time, but an employee could bring a claim from a longer period of time. So perhaps it bodes well to maintain records for a longer period of time to be able to demonstrate those. And I raise all of that for this question of what does an inspection look like? I'll start with from the state level. An inspector could come into your workplace any day and say, I want the payroll records for employee X. And Maine law requires that you are able to produce those records immediately. During that conversation, that day, you are required to be able to produce all of these records that you're required under law to maintain. This can be challenging, I would say, depending on the size of employer. I've seen with smaller employers that they may maintain a hard copy, written records, written in ink, stapled together in a filing cabinet. And it pragmatically is just not possible for them to be able to hand over these records immediately. That's not to say that they don't have the records, but physically being able to produce them can be really challenging. Whereas if you keep these records in ADP as a larger employer, you click a couple buttons and you can print out some documents. And that's, certainly a much more straightforward task. So I would say that the best practice to prepare if that were to ever occur, if there were ever to be an inspection, is the question, could you today be able to provide 3 years worth of payroll records about any of your employees if it were requested this afternoon? And if you can, then you are in a good position to be able to respond to an inspection of that type. And if you can't, that's not to say that there would necessarily be a problem. You might be subject to a penalty for not being able to provide those materials immediately. But the real question is, do they exist? Can you produce them? And then they would be reviewed accordingly. Happy to let others jump in if they have any thoughts or any thoughts on the federal side.
Sure. So I can definitely speak on the federal side. As Paige said, you want to keep your records for 3 years. If we do an investigation, we're going to ask for 2 years, unless we find that it is a willful violation. At that point, we're going to ask for the 3 years. In addition to it, you also want to have a list of your employees with their address, their phone numbers, emails, their date of birth, especially if they're under the age of 19. We're going to request that. And just remember, records are your friends. As much as they protect the employees, they also protect you as the employer, because when we come in, that is one of the first things we're looking at. We will talk to your employees as well, but we're going to be looking at the records to see if they're true and accurate. And I just wanted to kind of say, because people ask, well, what is, generally the first question we get is, why am I being investigated? And we cannot tell you the reason why. Okay. It could be a complaint or it could be directed. And I would say it's a 50-50 shot. But regardless, it's done the same way, whether it's complaint based or directed. And just know, like the state of Maine, we have the ability to just show up. Many times we will give you a heads up and we will say, we're going to come in the next 72 hours. We'll set a time to meet, but we do have the ability to just show up and request the records. At that time, we'll also do an initial conference where we'll talk to you, the employer. It could be a manager. We're just going to learn more about the business. And then we'll ask for a walkthrough of your facilities. and will request to talk to employees. I know that we kind of talked back about this with retaliation when it came to ICE. If an employee decides to talk to us, you cannot retaliate against them for talking to us. You cannot ask them, what questions did they ask? What were your answers? That is considered retaliation, okay? An employee has the choice to say, no, I don't want to talk to you, and that is fine, and we will be respectful of that as well. Once we do all of our interviews, we will do, we'll look at the payroll, we'll look at the time cards, and if there are any back wages to compute, we will compute, and we will end with a final conference where we will present that to you. So I know that was really loaded. There's a lot to go into that, but that is what a federal investigation looks like. I'm assuming the state is pretty similar to that, though. I don't know if Paige, Anne Marie, or Peter can confirm that.
Yeah, I would say that it is relatively similar. And again, one helpful point to keep in mind is that you can say you're in compliance, but it's the records that demonstrate your compliance. And so in a state like Maine, where you could be liable for a violation 6 years in the past, even though you're not necessarily required to keep records for 6 years, that alone is a reason to consider keeping the records to demonstrate your compliance.
And
That's
I
a
would,
great point.
would chime in to just say, like, this should be a really cooperative process for terms of the employer. Engage counsel early, and this isn't normally, at least in my experience, it's not an adversarial process. Like, it's not something to be, you don't want to fight with an audit. You want to cooperate. You want to work with the auditor or the inspector. And council should understand that. And yeah, it's similar. My experience with Maine has been that way completely.
And I'll just jump in as a precursor to all of that, because you all are assuming that our wonderful employers have done all of this record keeping in an appropriate way. But if you are an employer and you are not keeping the records you need to be keeping, please make sure that you rectify that, because if the DOL comes and they want to see records and you do not have records to produce, then whatever the employee says I worked is going to be what they worked. So, and that's true even if maybe you have some records and then the employee's doing some other things, like they plow your parking lot just out of the goodness of their heart. Well, that's time worked. So all of those things, the email communications, the calling them after hours, just make sure you have a proper mechanism for making sure that all time is accounted for.
That's so true, Anne Marie. And there are times, we'll get a call from an employee say, hey, I'm working 50 hours a week and I'm not getting paid overtime. We come in, we look at the records. Like you said, as long as it's all accurate and been done properly, we can tell whether or not, yes, an employee is due overtime, or no, actually, you only work 39 hours a week, 40 hours a week, there's no overtime due. So that is where I say it is as much for the employees as it is for the employer to protect themselves. And to Peter's point, I would say when I was an investigator, I'm no longer in that position, absolutely retain counsel. We love it. Just because your counsel is going to really understand the ins and outs of the laws. There's so many little nuances to it. And we understand that for you, it's very personal. This is your business. We get how personal it is. Whereas kind of with the council, they take a little bit of that emotion out of it, where they can dialogue with us without that emotion. And just know we are not there to put you out of business. We are not there because of any negative anything. Even if there is a complaint, we're going in looking at everything kind of neutrally. We're neutral fact finders. We're neither there for the employee or the employer. And I think that's something just to keep in mind. We will try to come in and disrupt your business as little as possible. Obviously, some things like restaurants, it's very hard to do because you guys have lunch rushes and things of that nature, but we will try to do as little disruption as possible. I don't know if anyone has anything else to add. All right. And the last question is, what steps should I take as an employer to ensure compliance?
Sure, I think I might have already kind of covered that in part, and that's to keep good record keeping of all of these things that we talked about. Number one, you want to make sure that you're properly compensating your employees. And number two, you're demonstrating and maintaining proper records of the hours that they're working, the basis for their rate of pay, their regular rate, how many hours in the week that they work, and that you're also providing specific documentation to them of the same, of course. And those records are really valuable when these inspections, if these inspections were to ever come up. I will say, and this did make me chuckle a little bit when I did assist an employer once with an audit at the state level or an inspection. They provide a huge volume of documents. I did help them navigate that process. I did speak with the inspector on their behalf, and we produced all the records and never heard back. And the client said, "Well, what do I do now? Am I gonna find out what happened?" And I said, "No news is good news here." So, which is kind of a funny outcome, but
That is interesting that you never found back out. I mean, for us, we will close it out. We will let the employer know what is going on.
that's nice.
Yeah. That way you're not just sitting there thinking what's happening. I did add something in the chat. It's a phone number. It is 1-866-4-US-WAGE. If you have any questions, this goes with the compliance. If you are doing something and you're like, well, I'm not sure if this is compliant, give us a call. It is confidential. Even if we find out what your business's name is, we are not going to start an investigation. We want folks to call us so that we can help ensure compliance. We want everyone to be proactive rather than reactive. So if you have a question, give us a call. We can talk with you. We can find out if, help you get into compliance if you're doing things incorrectly. We now have a paid program, which is a self audit. If you are doing things incorrectly, you can always self report to us, which avoids potential litigation, civil money penalties, things of that nature. So we do have a lot of tools out there if you have questions on whether or not you are in compliance. But that's all I had to add. I don't know, Paige, Anne Marie, Peter, anything to add?
Well, I think we have a little bit of additional time. So this is slightly an extension of this topic, but it bears mentioning, I think, that while we're talking about wages and wage reporting, with the new PFML starting and all of the other PFML or FMLA programs and different leave related things, it's very helpful for an employer to be able to delineate when somebody is taking time on their time cards, what that time is attributed to. So because that goes to not only time worked, if the DOL were to come in and ask about wages, but also when somebody gets toward the end of what their entitled time is, you have good documentation to show that they've taken what they were entitled to. So I know that's a little off topic, but I think important to mention.
No, that is very important to mention in terms of the payroll. It is helpful to see, what everyone is being paid for, whether it's straight time, overtime, or, something else. So we do not have any questions in the Q&A portion or in the chat. So I don't know if we want to open the floor, I guess, to other topics, or we can give folks back their 20 minutes. All right. So I guess at this point, we will just let everyone go. We'll give you 20 minutes back of your time. There is one question that just came up. I'm not sure if I understand the question. If you have a clear guideline for a paid, typing slowly. Okay, thank you, Michael. 1 second while he types.
Can I just ask it?
Yeah, that's fine. I didn't know if you could take yourself off mute. So go right ahead.
So I was just curious if you have a clear guideline for a paid internship or externship or earn while you learn program, and employees, who are really ambitious get there an hour and a half early and they punch in. And no matter how many times you tell people, please don't punch in early, which is kind of what we ask them not to do, the records is the truth, the source of truth. And it's a challenge. And would the clear guidelines of the hours of the course help? So if it's an 8 to 4 course and they sort of sign on an attendance and dismissal policy, if you will, that's clearly outlining the hours. Would that be not only helpful, but would that be sort of a supporting document to this? I'm sure you're familiar with what I'm asking. Punching
Yeah.
early and late, leaving late.
Yeah. So there's kind of two parts to this. So the first part is that it is work-based learning, it sounds like. Is that correct? Is it through a school?
It's somewhat, yes.
Okay. So that is
Through
going to
the
be a little
employ
bit
through
different.
through the employer that's providing the education.
Okay.
Out,
So
they're employed just for the education, and then they may end up in a position. It's an earn while you learn program, if you will.
okay. So the simplest answer to this is it's going to come down to your policies. Okay. If an employee clocks in and is doing work to the benefit of the employer, because the definition of employee is suffer or permitted to work. So we are saying it is a benefit to the employer that the employee is working. So if they clock in an hour early and they start working, that is a benefit to you, regardless of not if you authorize those hours. Okay. You have to pay them for it. But you certainly can have a policy in place that says, hey, these are the hours you're set to work. If you come in early without authorization, you will get a verbal warning the first time. Second one is a written warning. Third is a suspension, fourth is termination, so on and so forth. However you want to word it, you can give them as many, like, not chances, but marks as you want. But it's going to come down to that policy.
Ugh.
You have to pay them for the hours that they are there and clocked in and working.
Yep.
But you can have a policy in place that will protect you and help protect you, if they're not following the rules. And if it's an earn to pay program or earn to work program, as you said too, you could also state clearly in that policy that even if you're learning on the job, it would not necessarily guarantee you a position if you do not follow, the rules in the policy.
Oh, that's a good. I just don't. I sort of hate to sort of discourage people from getting to work on time, if you will. So this is, it's sort of twofold, two sides of the
Yeah.
sword there. I don't want to be writing people up because that's when they're dropped off, but it's a punch-in thing. And so there's that. And can I just follow up with another sort of
Sure.
education work?
Can I just
So,
add one more thing to that
Oh.
before you move on?
sure.
So I've actually had that situation for a private employer, and the employee explained that after several times of being told you're clocking in too early, that her husband dropped her off at a particular time and that she couldn't do anything about that. And so that's why she was at work. So what we did, because she was a very dedicated and conscientious employee and couldn't help herself but to start working when she got there, which was very much appreciated, but also not okay because they weren't paying her for it. So we suggested that it was perfectly okay to be dropped off at that time, but that she had to go to the break room or somewhere that was not her devoted desk, so that there was no chance that whatever she was doing would be perceived as work time.
Yeah, it's hard when people can't help themselves. But and their intention is truly good. So the other sort of question I have, if let's say let's say you're a secretary, let's say you're that person who's the secretary at that place, and they are in school and working as a student in another capacity. And then they so we want it to be clear that they're not there on their work time. They're there on their student time. But sometimes the roles may cross, right? So if you're training somebody to do something and part of the job is answering the phone for their training, how do you clarify exactly? Do you have to list every task as this is that job, this is this job? And is it okay for the student to be asked to disclose that they're a employee and will not, they're there as a student and will not engage in work activity, if that makes sense? Let's just use an example of something like a certified nursing assistant training, or they work on a place as a certified nursing assistant, but they're in nursing school. Both of them may be the role of checking in on a patient. How do we make sure that they're not doing the role as of a CNA as they're in nursing school hours? That make, again, help within a good example?
I think if they're doing any type of work at that point, it's going to be hours worked. It needs to be paid, even if they are learning. Uh, I guess I'm not necessarily following. I don't know if anyone
Well,
has a better answer.
I think, yeah, maybe someone.
So if I understand your question correctly, it's like you can only have so much control over what individuals do in the workplace. And so, am I understanding correctly that you have these interns? The purpose of the internship is not to benefit the employer, it's to benefit the intern. And how do you control them? And how do you prevent them from doing things that benefit the employer and then inadvertently you're in a position where they're not going to be treated like interns anymore? Is that like, how do you keep them from
Exactly.
doing that?
Exactly.
Yeah, I mean, again, I think to Anna Maria's point earlier about coming into work early or staying late, I mean, it's like it's a big issue because employers are like, well, I don't want to pay, their inclination is to not pay people if they don't abide by the policy, but really, um, I think it's keeping clear a clear written description of what the function of the intern is, training people up on what the intern is allowed to do and or what people are allowed to do with the intern. I think it's really like you have to train the supervisors really closely. You have to train your employees really closely because they may be inclined to ask the intern to do this or that or perform this work for their benefit. Um, but I think you just have to make clear to the supervisors and employees that that is not the intern's function, and then keeping clear written descriptions of what the intern's function is. If they happen to go and do some work for the benefit of the employer, that's the thing. Like you can't kind of avoid that. Like if they do that, then they are, then we have to compensate them as employees. The way that you prevent that with your employees is through the disciplinary process. Like if you find out that an employee is assigning work to an intern that the employee is not supposed to be assigning, then the way we treat that is through discipline. Um, I don't know, maybe it's another term other than discipline, but does that make sense? Does that kind
Coaching
of answer
always
the question?
works.
Yeah, coaching. Yes, coaching. Productive, improvement-oriented conversations.
Thank you so much. I appreciate that.
Yeah.
It's hard. It's a gray area, but it is very clear in my mind. And I think you suggested the manager has to be aware that they're in a different capacity and not
Yep.
assign it. And
Yep.
that makes sense.
Yep.
Thank you, everyone. We did have a question come in the Q&A, so we're going to kind of switch back a little bit. I apologize. The question is, going back to the beginning of the conversation, my facility has a short-term training program and the ICE rates cause many students to leave or not come in at all. As the training program is a set period of time, this caused them not to meet program requirements and ineligible to finish the program. Would love suggestions of how to mitigate any risk related to this.
So these are students, not employees of any kind. Is that correct?
It's an
I
anonymous
didn't see
attendee,
it
so I
in the
don't know.
chat. I didn't see it in the chat.
Yeah, I didn't see
No,
it
it's in
either.
the Q&A.
Oh,
Oh, oh, oh, there it is. Yeah.
Looks like they're
Thank-
student
Short
employees.
term.
Oh, they are student. Cassandra, was that you that had answered? Or that said that they're student employees? She said, I can't find a microphone.
They're student
Jonathan,
employees,
Like,
she's saying.
yeah, I'm wondering like what kind of risk are we talking about? Like they're ineligible to finish the program, risk in terms of not giving them an opportunity to finish the program because of ICE and it's out of your control. In terms of a legal risk, I don't know what Paige or Anne Marie think, but like I don't see as the employer, like I mean it's out of your control.
Yeah, I
I
think
mean,
that, this might be more of a lowercase r risk question. And this is a tough one. And, we did talk a little bit earlier about how policies can provide a sense of predictability. But of course, at the end of the day, if an individual has concerns about opting into a program, they do have that discretion. And I would agree that from a legal risk assessment, that might not necessarily pose a challenge to a company or an employer, but it certainly in the interest of providing a service or a program or a training, this would impact the ability to do that.
thanks, Paige. There's something else. Oh, she just said thank you. Right now, we don't have any other questions. Just checking the chat and everything real quick just to make sure I saw everything. I don't know if anyone has anything else to add before we hop off. All right. Well, thank you, everyone. Thank you for the questions to Michael and Cassandra. It was appreciated. If you have any questions further on, you can probably send those over to the organizer. But if not, we'll give people back some time. Thank you so much, everyone.